Um,
Please raise your right hand and be sworn. You swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God?
yes, I swear, Your Honor.
Thank you. You may proceed, Ms. White.
Mr. Ntwala, did you contact Community Corrections?
Yes, I did.
Did you go?
Correction, yes, I did via email.
Okay. And what was it that you said in that email to Community Corrections?
I was concerned about the alcohol monitor that was installed on my ankle after my release. That was my very first time to have a download, and I didn't know how often I could get a download, because when I was released, I went there in person at the community correction office. I signed in on the sheets that they have daily. I talked to the agent Brandon Casey in person, and also I asked him about the vibration of the monitor. I thought I was going to charge it daily, but he said, "Do not worry about the vibration." And also, I asked him in person about how often I could get it downloaded. He said that it would be a while until from the very first day that I got out of jail. So he was going to contact me via phone, but I lost my phone.
And so you sent an email?
Yes, I sent an email. I went there in person, then I sent him an email. I still have records of the email that I sent to him on my Gmail account.
Okay. Did you also contact probation?
Over the phone, yes. And the representative at the probation, 14B probation, refer me to Ypsilanti mental health court with for a screening, and I went there in person the next day. I was screened, and I was subject to go back for a next appointment there, but unfortunately I ended up being incarcerated.
When you contacted probation, did they tell you to go to Community Corrections?
That's correct. And I
Did they,
to go to mental health in Ypsilanti.
Did they tell you to go to Community Corrections?
No, just the mental health court, Ypsilanti, CMH, Ypsilanti.
Did they say anything to you about the downloads?
Not at all.
Okay, I believe that's all my questions.
Any questions?
No further questions.
Any questions from you, Ms. McDuffie?
Just one. Mr. Ntwala, when you spoke to somebody from 14B probation that told you to go to mental health?
Yes.
Who'd you talk to?
I can't recall the name, but I have made a call. And also, when I talked to that representative at the 14B probation, that's when I do believe that I was told by the representative that the agent at the community correction sent them an email that I think contacted them too, but I told them that I was waiting on their response because I contact community correction via email.
Just to the best that you can remember, when you talked to that person at 14B probation, do you remember if it was a lady's voice or a man's voice?
It was a woman. It was a woman's voice.
Okay, I don't have any further questions. Thank you, Your Honor.
No questions based on that.
Thank you. Anything further from anybody else? Any other additional witnesses?
No, Your Honor.
All right. Brief argument, very, very brief.
Yes, Your Honor. My argument is that I don't understand why we're having this hearing. It's a very simple question as to whether or not Mr. Ntwala reported for a download. And what he has, we heard from Agent Casey, who explained the process. He said he verbally told him, spoke to Agent Johnson about the fact that he didn't have any contact with him. My biggest concern here is not only Mr. Ntwala being honest with the court, but honest with himself. And he just testified here today that he called Agent Casey, or rather that he went directly to get his tether, and he was given a vague answer as to Agent Casey saying it'll be a while and to contact him about when he's supposed to report. That really doesn't make any sense, that you would be fitted with this gram tether and not be told, don't worry about it, I'll let you know when you have to come back. But furthermore, he then states that after that point, he lost his phone and he sent Agent Casey an email because he didn't have a phone. He also just testified that he had a phone when he called 14B probation because he remembers speaking to a woman over the phone. So it's really not clear to the people why Mr. Ntwala was not able to use his phone and contact community corrections during this entire time. And we're talking about a 2-month period between his incarceration and when he had this tether on, and why there's no phone, or why the phone reappears and he's able to have phone conversations with this court saying that he was misdirected essentially to mental health services when he specifically called about that tether. So I have some concerns about his honesty generally, and this hearing is unfortunate, but I believe that it's been shown by the standard of evidence that were required to show that Mr. Ntwala indeed failed to report for his tether downloads as ordered.
Ms. White.
Mr. Ntwala did attempt to do the downloads. As soon as he was released from jail, he followed orders and went to community corrections. He did speak with Agent Casey. In his mind, he thought he had to do the download right then. He was told it was too soon and to come back. His understanding was to come back later and that he would then do the download, because he did follow up by email to ask about those downloads. He said he did not get a response. After not getting a response, he contacted 14B. Instead of being told about the downloads, he asked what specifically he needed to do, and he was told to go do the mental health appointment. He was not told anything. Mr. Ntwala states he was not told anything about the downloads, the tether, or anything else he was supposed to do, just to go to the mental health appointment, which he did. So I believe that Mr. Ntwala states that because of those things, and he did reach out twice, he was not told any other additional things to do, that he did do everything he was supposed to do. That he thought he was supposed to do. Sorry, let me rephrase that.
Everything that Mr. Ntwala said about this hearing today is pretty much incredulous. And for all the reasons stated by the prosecutor, he is guilty of this violation. And what do you want to do about, I believe, at this point in time, we still need to have the sentencing? Well, we already had the sentencing. So we need to have a sentencing on the violation. And I will bring him back for that.
And Your Honor, it looks like he's going to be in at least until July 5th on his 14A1 case.
No, Crash, I'm actually attending Dawn From program. If I do complete that program, then Judge Simpson has said that he will consider early release as soon as I complete the Dawn From program.
Interesting for you and Judge Simpson. All right, I'm going to bring you back for sentencing in this particular case. On March 21st, 2024 at 10 o'clock a.m.
I'm sorry, what was that date one more time?
March 21st.
Thank you.
All right, I'm letting in our people from our final settlement conference docket right now.